Welcome to today's webinar, Federal and State Preemptive Basics, What Every Drafter Ought to Know, brought to you by NCSL. It is now my pleasure to turn the floor over to Kay Warnock. The floor is yours.
Hello, everyone. This webinar is sponsored by the Legal Services Staff Section and the Research and Committee Staff Section and is supported by an NCSL e-learning grant. Over 150 registrants from 39 states and the District of Columbia are participating today. This webinar is being recorded, and it will be posted on the NCSL website in about a week for the use of legislative staff unable to attend the presentation. If you need copies of the slides, you can click the Media Library icon on the upper right-hand corner of your screen to download the presentation. It looks like a yellow piece of paper with a blue bar graph in front of it. The presentation is also linked from this webinar's homepage if you would like to download it later, and that is also where you will find the recording of the presentation in about a week. We will be taking questions at the end of the webinar using the chat box in the lower left-hand corner of your screen. Please feel free to type any questions in the chat box during the webinar, and we will answer them at the end of the presentation. Our speaker today is Erin Smith, Legislative Counsel from the Texas Legislative Council. Welcome, Erin.
Hey, Kay. Thanks so much. Hi, everybody. As Kay said, my name is Erin Smith, and I'm a drafting attorney at Texas Legislative Council. In Texas, we divide up our office into subject areas, so I predominantly draft in the areas of business and commerce, ethics and campaign finance, health occupations, and health and human services. And I'm excited to be here today to talk about the basics of federal and state preemption. Just a disclosure before we get started, there is a lot of legal scholarship out there about federal and state preemption doctrines, but today's presentation is not going to focus so much on the intricacies of that scholarship. It's going to be more of a primer of the basics of those doctrines, and then I'm going to spend most of my time talking about how to effectively draft legislative requests that involve state or federal preemption. So that having been said, let's go ahead and get started. Just a roadmap of where we're going to go today. I'm going to begin by introducing the doctrine of federal preemption of state law. Then I'm going to talk about some processes for handling legislative draft requests that involve federal preemption. Then I'm going to move into state preemption of local law. And then I'm going to talk about some checklists and processes that I've developed for handling legislative draft requests that involve state preemption. So federal preemption of state law. The general law with regard to federal preemption is that when federal and state law conflict, federal law preempts state law. This general rule is derived from the Supremacy Clause of the United States Constitution, which establishes the primacy of federal law over state law. And you can see on the slide the text of this provision from the Constitution. It's important to note that when you're talking about federal preemption, that preemption can occur regardless of whether the conflicting laws come from constitutions, legislatures, administrative agencies, or courts. And the types of laws that are conflicting don't necessarily have to be parallel. For example, you could have a federal constitutional provision that preempts a state statute, or you could have a state court opinion that's preempted by a federal regulation. Just a few notes on preemption jurisprudence, how courts decide whether or not state law is preempted by federal law. When courts are making these decisions, they're going to look to statutory interpretation. They're going to try to figure out what Congress's intent was in enacting the law. And in the case of a regulation, they're going to look back at the statute that delegated the authority to the agency to be able to preempt state action. Generally, when the intent of Congress is unclear, courts prefer an interpretation that avoids preemption. And this so-called presumption against preemption is stronger in certain categories of cases, specifically those cases implicating police powers, cases on matters of public health and safety, and tort cases with traditional state law remedies. If the intent of Congress is to preempt, if this is what a court finds, then the court's next step is to insert in the scope of preemption. How much is Congress intending to preempt? And then the result of these cases, when courts find that a federal law preempts a state law, is that the state law is invalid. except in less circumstances where the federal law is itself invalid. In looking at preemption jurisprudence, both at the Supreme Court level and at the lower appellate and federal district courts, there's generally two types of preemption that courts discuss. There's what we call express preemption, where Congress indicates preemptive intent through a law's express language. And then there's also what we like to call implied preemption, where Congress indicates preemptive intent not through express language, but through a law's purpose or structure. In the realm of express preemption, if a federal law contains express preemption, you're still going to have the question of the scope of the preemption. And generally, we like to talk about three different types of express preemption, three different sort of spaces on the spectrum of how widely preemption goes. You can have complete preemption, where the federal government completely takes over an area of the law. You can have partial preemption, where the federal government and the state share power over an area of law, or there are certain circumstances that are generally dubbed contingent preemption, where the preemptive effect of a federal law is contingent on certain circumstances. Implied preemption has also been interpreted by the courts to break down in a couple of different ways. There's generally what's recognized as conflict preemption, where a state law conflicts with a federal law, and then there's field preemption, where a federal regulatory scheme is so pervasive as to occupy the field in an area of law. And in a lot of cases, conflict preemption breaks down further into physical impossibility or actual conflict preemption, where it's physically impossible to comply with both a federal law and a state law. And then there's also what a lot of courts have called obstacle prevention, where a state law is an obstacle to the accomplishment of Congress's purposes or objectives. So that's sort of a general bird's eye view of federal preemption and some of the major types of preemption that the courts have identified. I'm now going to turn my attention to how to handle legislative draft requests that involve federal preemption. And I've sort of developed a process for handling these types of drafts. I'm going to start by going through what I've kind of titled a prologue, kind of how do you prepare for receiving these types of drafts that may come across your desk. And then when you actually have a draft that involves issues of federal preemption, how do you handle it? I'm going to talk about being politically sensitive, understanding the requester's intent with regard to the draft, informing the requester how you counsel them about the preemption, and then what particular action you might take based on the requester's preference and concern for any potential preemption problems posed by the request. So that's where we're going. And we're going to go ahead and start with the prologue, which is something that you can do today, even if you don't have any preemption request on your desk or your legislature is not in session. It's good to anticipate on what subjects and in what context you may receive draft requests involving federal preemption. And there's several different aspects of kind of preparing for these types of requests. And I think the first and the most important aspects of preparing for these kind of drafts is familiarizing yourself with the major federal constitutional provisions, statutes, and regulations that may preempt state action in the areas in which you draft. In Texas, some of the subject areas where we tend to see a lot of preemption-related requests are areas like transportation, labor, insurance, environment, and certainly voting in elections. Some constitutional provisions that we often find limits what our requesters are trying to do in letting states act in certain areas are provisions like the Commerce Clause, Congress's power to establish uniform naturalization and bankruptcy laws, and some of the general provisions in the Constitution about prohibiting states from entering treaties, doing things like coining money, and imposing tariffs. Also, some federal statutes that tend to tie our requesters' hands in wanting to do things on the state level are statutes like the Dodd-Frank Act, of course, the Federal Food, Drug, and Cosmetic Act, ERISA, the Clean Air Act, and the Voting Rights Act and the Federal Arbitration Act. So these are statutes that in constitutional provisions that we try to familiarize ourselves with within Texas and are aware of when requests are coming to us that might involve federal preemption. Once you've sort of identified those statutes that might constrain what state actors are trying to do in areas in which you work. It's important to know that when you're reading those statutes and trying to understand them, that the express preemption language in those statutes does vary from statute to statute. I give an example up here of ERISA, which ERISA is the federal statute that establishes exclusive federal jurisdiction over employee benefits plans that are administered by private sector employees. And ERISA is a great example of a statute that has a very clear express preemption clause. This clause has been subject to much interpretation by the courts, and it's something that you can definitively point to and show ERISA's preemptive effect when you're talking about it with requesters. It also includes a very specific savings clause that carves out authority for the states with regard to still being able to control matters related to insurance, banking, and securities. In other statutes, the preemptive effect is not so clear, and an example of one of those types of statutes is the Federal Food, Drug, and Cosmetic Act. This particular act gives the FDA authority over these types of products, but doesn't have that express preemption language like ERISA does. It's been more through the process of courts interpreting the statute that its preemptive effect has come to be known. I do note up here that the medical device amendments to that particular statute do have an express preemption clause, so sometimes you really have to unpackage a statute and really look at the different parts to figure out what parts have express preemptive language and then what parts may just have preemptive effect or not preemptive effect. One thing to keep in mind when you're kind of gathering yourself and understanding the statutes that might create preemption problems in the areas in which you work is that in the field of regulations, generally express preemption language is pretty favored. This has certainly been the case under the Obama administration. Shortly after taking office, President Obama issued a presidential memorandum regarding preemption. And in that memo, his administration made clear to executive agencies and executive departments that they should, to the extent that it's allowed or that they're able to, not include preemption statements in regulatory preambles unless they're in codified regulations, and then to not include preemption provisions, of course, in codified regulations unless they're justified under legal principles governing preemption. And this particular memo also instructed those agencies and those departments to really look at what they had done in the last 10 years and make sure that when they are intending to preempt state action in a certain area, that they made clear that they were going to do so in the actual codified regulations, and that when they did so, they were justified under legal principles governing preemption. So once you've kind of gotten the lay of the land of the statutes, constitutional provisions, and regulations that might influence preemption or cause state action to be preempted in the areas in which you work, it's also important to keep up to date with developments in jurisprudence related to those constitutional provisions, statutes, regulations. For example, preemption it's not static. It can change over time. And an example of this would be the Dodd-Frank Act. The Dodd-Frank Act actually changed preemption standards for state laws affecting national banks and federal thrifts. It eliminated federal preemption of state laws affecting subsidiaries of national banks and federal thrifts. Prior to Dodd-Frank, state regulation of those entities had been preempted, and it also applied the same preemption standard to federal thrifts as that which had existed for national banks. It uniformly applied conflict instead of field preemption to federal thrifts. And finally, it narrowed the preemption standard for state consumer financial laws, so that they're only preempted if they have a discriminatory effect on national banks, if they significantly interfere with the national bank's exercise of its powers, or if they're preempted by another federal law. Also, when thinking about preemption jurisprudence and keeping up with what's going on with a particular statute, it's important to remember that preemption standards are continually subject to interpretation by the courts. The heart of how a statute might preempt state action is often in the jurisprudence and in the interpretations of those statutes, not in the text of the statutes themselves. And generally, when you look at all of these decisions interpreting statutes and understanding their preempted effect, there's two types of cases. There's cases that present questions about legislation and whether a state has the authority to act in an area governed by federal law, and then there's those types of cases that present questions about litigation and whether federal law prevents plaintiffs from bringing state law claims. Finally, when you're getting yourself ready to draft requests that might involve federal preemption, it's important to be aware of state statutes and regulatory schemes that are limited by preemption in the areas in which you draft. And I think a great example of this also relates to ERISA, which I mentioned before. A lot of states, including Texas, have a lot of state law on the books that governs health plans and other employee benefit plans. And at first blush in reading these statutes, you might think that when you amend those statutes, you're reaching all health plans that everyone in your state has. But it's actually only the health plans that aren't governed, preempted by ERISA. So it's good to be aware of different areas in state statutes and state regulations where it might look on the surface as if they regulate more than they actually do, because they actually bump up against what the federal law is requiring, and they're affected by federal statutes and federal regulations. So I think that brings us to the end of our preparatory stage and our preparation for dealing with drafts that involve federal preemption. And now I'm going to go into the actual steps for how to handle these requests when you actually have a real live request that involves federal preemption. And the first step in this process is to handle the request with political sensitivity. I think a lot of times when we think about preemption, it can seem like a very academic topic. It's something we talked about in law school. It can seem to be very almost scholarly or academic. But discussions of preemption can raise questions or invite opinions about federalism and the balance of power between the federal government and the states. Topics can often be very controversial and that our requesters might have very strong opinions about. Also, support for preemption may vary significantly depending on the state action to be preempted. Universally, there's no party that generally supports federal preemption or is opposed to it. It varies a lot depending on what the subject matter is. So it's not an easy area to make assumption as far as whether a requester is going to like the fact that their action might be preempted or they're going to not like that. You don't know really what to anticipate sometimes in a field of federal preemption, so it's something you want to handle with care. Once you've kind of begun approaching the request with political sensitivity, the first thing you're really going to dive in and try to figure out is what's the requester's intent vis-a-vis the federal law? What is your requester wanting to do? Are they wanting to do something that's in conflict with federal law? Are they trying to just simply replicate federal law? Are they looking to do something that's stricter than federal law, more lenient than federal law? Or are they trying to do something that's just a little bit different than federal law? It's related, but maybe not quite the same. And the Massachusetts Legislative Research and Drafting Manual actually includes some of these questions in their legislative research checklist. And where possible in the presentation, I've tried to highlight certain practices by states and mentions of other states' drafting manuals so far as they relate to preemption. And I think this is a really great example of how one state deals with these questions. And I think it's something to think about when you're developing maybe checklists for new drafters or experienced drafters and things that you want to keep in mind on every request. I think certainly questions about how what your requester is trying to do may be impacted by federal law is something that's important to keep in mind in all requests. Step 3 of the process, once you kind of figure out what your client's trying to do vis-a-vis the federal law, is to then inform the client or the requester about the potential preemption. And these types of conversations can really run the gamut. It really varies based on the client's familiarity with preemption. Some clients might be brand new to the doctrine, and you might have the chance to talk to them about express preemption and implied preemption and really introduce them to how the Supremacy Clause constrains what states can do sometimes. Other times you might have very sophisticated clients who are very well-versed in the doctrine, and they may appreciate you supplying that language from the ERISA statute and showing where the express preemption language is in the statute, or they may ask for cases interpreting the scope of preemption. So these conversations are going to be variable, and depending on how well you know the requester or how familiar you are with the client, they're going to vary. And so once you've had those conversations, the next thing is to take action. You're either going to draft the request as they've requested, or in certain circumstances you might make some adjustments based on what they're concerned for potential preemption problems with the draft. And so I'm going to begin by talking about the first situation where the drafter or the requester may want you to continue with the draft as they've requested it. And there's a lot of circumstances, and I'm going to go through a few here, where this is a very valid decision. Even if a draft might potentially bump up against some federal preemption statute or regulation, there's a lot of valid reasons for continuing with it in many circumstances. For example, the requester may want to make a political statement. Even in an area of the law where it's been pretty settled that the federal government has the last say, your requester still may want a draft in hand that imposes a state regulatory scheme in that area. Just they may want a reason to be able to talk about it on the House or Senate floor, and they may just want to offer it for political reasons. And the same thing, they may want to mirror federal law as well. Of course, federal law applies on its own terms, but for political reasons, a requester may want to see federal law replicated on the state books, and just to make that clear to constituents or to people in the state that law applies. Another reason a requester may want to continue with the request even if there's potential preemption problems is that the requester may believe that the federal law is invalid. As I spoke about before, a state law is preempted by federal law only to the extent of the validity of the federal law. So the constitutionality of the federal law is in question, then this might be a situation where they want to continue with their request even if it looks like it's going to be preempted by the federal law that's currently on the books. A third situation where you might see a requester want to continue with the request as is if the requester believes that the preemptive effect of the federal law is unsettled or in flux. Again, I spoke about Dodd-Frank and how that particular statute changed the preemption standard for federal thrifts and for national banks. And there's always a possibility for Congress to amend its statute and for courts to interpret things differently. So there might be a case where that's going on, and they want to continue to still regulate, have the state regulate an area until that federal preemption issue gets settled. And finally, there may be an enforcement issue, and I have an example in here of I think is a really good example of the government's decision to enforce statute in a certain way. The Department of Justice has provided guidance to federal prosecutors on the enforcement of marijuana laws. And the Department of Justice has been very clear that the Controlled Substance Act does, in fact, make the use of marijuana illegal, but they've provided guidance and allows federal prosecutors to use discretion in deciding whether or not to prosecute persons whose medicinal or recreational use of marijuana is in compliance with state laws allowing them to do so. So if you're in a situation like this where the federal government has chosen in certain circumstances not to enforce a particular law, it might make sense for the state to step in and regulate that in the way that they would find desirable. So there's a couple of excerpts here from a couple of different memos from the DOJ. And then shifting gears and moving on to the next part of the presentation, I'm going to now mention some situations where requesters may want to change course based on potential preemption problems that you've identified or highlighted for them about their request. There's a couple different fixes that I've highlighted here that we've used in Texas in certain circumstances. You might consider offering to include language in the draft that acknowledges state action is limited by federal preemption. Now, of course, federal law applies on its own terms, but a requester who is concerned about their particular piece of legislation being preempted by federal law, might want to make clear that that's not their intention, that they want the state law to apply only to the extent allowed under the federal law. They also may want to include language like this to signal to people who are going to enforce the law or implement the law or be bound by the law that what appears on the books in the state part of the regulatory scheme is bound by what's more broadly dictated by federal law, and just sort of make that indication clear when you're reading the law that's on the books in the state. And so I've put some examples up here of Texas statutes that have very explicit language about the bounds of how the law is able to be exercised in relation to federal law. For example, you can say that a certain section or provision, it doesn't apply to the extent that it's preempted. It applies only to the extent it's preempted. It only applies until preemptive laws take effect. So that's something that you can consider offering to include if your requester is concerned about preemption. You could also consider offering to include in the draft a severability clause, or ensure that when applied to the draft. And severability clauses protect the validity of a statute. If part of the statute is struck down, it basically allows the remainder of the statute that isn't found to be unconstitutional to continue on. And that's really important in the preemption context, where if part of the statute might be preempted by federal law, you want to make sure that the rest of the statute will continue to live on and be enforced. And in Texas, we have something called the Code Construction Act, which contains a severability provision that applies to all of the codified statutes. So we don't have to put those severability clauses in all of our drafts. But I don't know if all states have such a uniform provision, so it's something to consider. Or even if you do have a uniform provision, it's definitely something to bring to the attention of requesters so they know that that's there. Finally, another thing that you might consider offering to do if a request poses preemption problems is to draft a request to Congress to amend the federal law. This could be done in conjunction with preparing the request or in place of preparing what had initially been requested. And in Texas, we do this through a couple of different vehicles. Sometimes our requesters or clients will want us to request action from Congress, request that Congress repeal a certain law, amend a certain law, adopt regulation of some matter, and we can express our preference for Congress to do this through concurrent resolution. We also have joint resolutions in Texas, which don't have to be signed by the governor and can be used when one of our requesters want to request a convention to consider amendments to the United States Constitution. So a different approach that, again, can be used in conjunction with the bill in Texas. Finally, before we shift gears and move to a discussion of state preemption, I just want to mention briefly effective preemption, or what I'm titling effective preemption. There's some federal laws that don't preempt state action, but that condition the receipt of such large amounts of federal funding on state compliance with certain requirements that state non-compliance with these requirements is effectively preempted. And these types of requests come up a lot in subject areas like transportation, education, and health and human services. And in these circumstances, it's not necessarily, there's not generally a constitutional problem, but you do need to advise the requester of the potential loss of federal funding if you continue with the request as is. And if appropriate, a sort of help that you could offer or fix would be to include waiver language, which directs the state to seek a waiver of federal requirements before implementing the legislation. And again, I have another excerpt from a state's drafting manual up here. The Wisconsin Bill Drafting Manual discusses these, what they title conflict requests and how to handle them. And then I've also included in the presentation our Texas standard waiver language, which I actually use a lot when I'm drafting requests in the welfare and human services area. Lots of times clients, or sometimes clients, may want to do changes to the Medicaid program or the SNAP or food stamps program that basically aren't in compliance with what's required under federal law. So we usually include this standard language to ensure that our states won't do anything until basically they receive a waiver from these requirements, so we don't jeopardize our funding or anything like that. So that concludes the first half of the presentation. We've kind of now we're going to jump from federal preemption to state preemption. So we're going to move down a level and talk about, again, the doctrine of state preemption, and then how to handle requests that involve state preemption. So we're going to head that way now. The general rule with state preemption is very similar to the general rule with federal preemption. When state law and local law conflict, state law preempts local law. The bigger, higher level of law prevails. This general rule is derived from the 10th Amendment to the U.S. Constitution. And again, I put the text up here. Of course, the powers not delegated to the U.S. or prohibited by it to the states are reserved to the states. Local governments are not mentioned in the Constitution. They actually don't have any federal constitutional authority, and their only powers are those granted or delegated by the states. And this has been pretty clear in U.S. jurisprudence since the beginning. I have a quote up here from an early Supreme Court case from the beginning of last century that talks about municipal corporations being creations of the state. Municipal corporations being creations of the state, and all of their powers and abilities being at the discretion of the state. So, something that's important to note in the realm of state preemption is that while all local governments derive their powers from the states, the extent of that authority varies from state to state. And I'm going to talk briefly about two sort of traditional ways that states shared authority with or delegated powers to local governments. In Dillon's rule states, local governments generally have narrower authority. A Dillon's rule local government can only exercise powers specifically granted to it by the states. And this rule comes from the name of an Iowa Supreme Court justice who developed this rule through his decisions and scholarships in the late 1860s and 1870s. The other traditional method for states to allocate powers and authorities to local governments is through home rule. And in a home rule state, local governments generally have broader authority. A home rule local government is delegated powers by the state and can exercise those powers subject only to limitations imposed by the state. Home rule really became popular in the late 1800s and 1900s and early 1900s in response to Dillon's rule. A lot of local governments were feeling constrained with continually having to petition state legislatures for powers to do certain things. So states began to enact constitutional provisions and statutory provisions that went ahead and allocated authority to localities to act without continuing to get express permission from the states, and gave them general powers that they could exercise subject to, just limitations imposed by the states. It's important to note that there are very few states out there that are purely Dillon's rule or purely home rule states. Most states operate under a combination of the two types of rules or some of their own unique jurisprudence. Those are kind of just the two hallmark traditional ways of allocating authority to local governments. But every state is different. Every state has sort of their own practice for delegating authority to localities. So now that we've kind of gone over just a real basic view of state preemption and how state governments might allocate power to local governments, I'm going to now go through processes for handling legislative draft requests that involve state preemption. And again, I have a couple of prologue steps, a couple of things that you can do even now to sort of prepare for receiving these types of requests. And then I'm going to talk about two different situations. I think as a drafter, sometimes you receive requests where your client or requester wants you to expressly preempt local regulation in an area, and sometimes they may want you to do something that impliedly is going to preempt local authority or the potential for local authority in a certain area. So I'm going to kind of divide up those two situations. And then just like I did before in the federal context, we're going to work through steps as far as dealing with the request with political sensitivity, counseling the client, and then actually preparing the draft. So let's start with, of course, our prologue steps, what you can do to prepare for drafts involving state preemption. The first thing that I think is important to do, no matter what area you draft in, is to understand the relationship between your state and local governments in your state. As I mentioned before, this is going to vary quite a bit from state to state. So think about, does your state, is it a Dillon's Rule state? Is it a home rule state? Does it apply its own sort of unique jurisprudence of allocating authority to local governments? And since I'm from Texas, I'm going to give just a little bit of an overview of Texas's allocation of authority. Traditionally, courts have applied Dillon's Rule, and most local governments are governed by general rule. But the vast majority of people actually end up living in home rule cities because the Texas Constitution has a special provision that allows cities with more than 5,000 inhabitants to adopt and amend their own charters. And we also have a special provision in our education code for home rule school district charters to be formed, although currently we don't actually have any of those charters operating in Texas right now. Also pay special attention when you're looking at the relationship between your state and local governments in your state to constitutional provisions expressly prohibiting the state from enacting certain laws or affecting certain laws affecting local governments. For example, again, in Texas, we have a prohibition against special or local laws, and local laws are those that affect only a specific local government or a very narrow geographic area of the state, and special laws are laws that only affect a particular person or a very narrow class of persons. And our Constitution bars these type of laws from being passed. We can't pass laws that specifically only affect Dallas or Houston or only affect lawyers in Amarillo or bankers in Austin. We can't pass these types of statutes in Texas. Also pay special attention to state constitutional provisions expressly granting or delegating power to local governments. And that's the case in Ohio. Ohio actually has a provision in their constitution which delegates certain authority to municipalities outside the powers that are granted in that state's revised code. And they're given powers of local self-government, and they're allowed to exercise certain local police, sanitary, and other similar powers by the Constitution, regardless of what's in the code. Also pay special attention to state constitutional provisions that have been interpreted as conferring certain powers or duties on local governments, and that's the case with the Pennsylvania Constitution. I have here their Environmental Rights Amendment, and this amendment basically gives, it makes a fundamental right of the residents of that state the preservation of the natural resources of that state. That's a right of the people there, and it gives the Commonwealth, it makes the Commonwealth a trustee of those resources, and the Commonwealth has been interpreted to include local governments. And so, using this particular statute, the Pennsylvania Supreme Court actually struck down a state statute that provided for the state to occupy the field of oil and gas regulation. It found that by completely removing local government's authority to act in the field of oil and gas regulation, they couldn't discharge their obligations as trustees of the state's public natural resources. So ultimately that statute was found to be in violation of the Pennsylvania Constitution. So once you've kind of gotten the lay of the land as far as how local governments relate to your state, you also want to think about what subjects and in what context you may receive draft requests involving state preemption. So ways to do this are to think about previously introduced state legislation that contain preemption provisions. Generally, if a legislature has tried to do something that hasn't worked in the past, another legislator will pick it up in next session and try again. Look out for legislation passed by other states that expressly preempt or has been interpreted to preempt local law. It's very rare for one jurisdiction to be doing something that no other jurisdiction has thought about or has tried. For instance, some of the taking the control of oil and gas regulation out of municipalities has been spreading throughout the country. There's several different jurisdictions that have passed bills doing that same sort of thing. And also stay updated about hot topics in local politics in your state and nationwide. Usually if localities are being very active in a certain area, somebody on the state level is going to take notice, and they're going to either really like what the local governments are doing and want to impose it statewide, or they're not going to like what they're doing and are going to want to effectively shut it down. And these are some local hot topics that we've talked about in Texas, and I think a lot of them, again, you're going to see in your states and in other states nationwide. Things like oil and gas operations, fracking, smoking, texting while driving, payday lending, public restrooms, and regulation of knives and other weapons. So now that you're sort of prepared to handle legislative draft requests involving state preemption, I'm going to take you through what you're actually going to do when you have one of those requests in hand. And as I mentioned before, the first situation that you might see these particular types of requests is where the requester wants to expressly preempt local law on some matter. They know that's what they want to do, and they want you to help them achieve that goal. So the first thing you're going to do when you receive one of those requests is, again, think about being politically sensitive. Handle the request with care. Just like in the federal context, support for preemption of a particular matter may vary among Republicans and Democrats, urban and rural districts, geographic regions of the state. It's not always going to be immediately apparent when you receive a request for preempting local authority whether the requester is doing that because they want to spread what a locality has done statewide. They really like what the localities are doing, so they want to bring it up to the state level, or they may not like what the localities are doing and want to change course. And so a lot of times on the face of the request, it's not going to be evident, and it's not going to be evident based on where the requester comes from, if they're from an urban district or rural district, or if they're a D or an R. You may not know kind of where, because preemption just is so different depending on what the issue is. If applicable, you're going to want to inform the requester about any state constitutional provisions that may affect the preemption of local authority on the matter. And again, this is a great time to bring up things like Texas's prohibition against special or local laws. If you have something like the Pennsylvania Environmental Rights Amendment, this is a great time to bring it up. This is a time to let them know about anything in your state's constitution that may restrict what a state can do vis-a-vis local authorities. And then, let's see, step 3, if helpful, you're going to want to provide the requester with representative local ordinances or rules that may be affected by the legislation. And this is important, especially in a state like Texas, where we're very big. What one requester may be aware of what localities are doing in their district and in neighboring districts, but they may not know what's happening way on the other side of the state. So this is an opportunity to make sure that when they're preempting local law, they know what it is, in fact, the extent of what they're preempting. So when appropriate, this can be really helpful to requesters in determining how far they want to preempt. So once you've provided the legal information and maybe some practical information as far as what local ordinances or regulations might be preempted, it's time to really begin working on the draft. And the first part of this means determining the requester's intent with regard to the scope and specificity of the matter to be preempted. You're going to want to try to figure out if the requester wants to preempt local authority more narrowly or more broadly. Do they want to be more general or more specific? And I've put a couple of examples up here about, or from the Texas statutes, where we can be very general about what we're preempting. For example, here, just the regulation of these particular types of loans in the finance code, or sometimes the requester is going to want us to be very specific. I have a provision up here from the agricultural code where we are being very specific that we want to preempt all aspects of commercial fertilizer, everything from the registration, the labeling, the sale, distribution, and use. So that's going to be the judgment call of the requester, and it's something to kind of figure out what scope they want the preemption to take. And also, I want to make a note here that you do want to handle with special care requests for preemption of a whole class of local activity. Sometimes requesters might want to require all local ballot initiatives to be approved by the state, or all local ordinances that are more stringent than state statutes to be prohibited. And sometimes this is, in fact, the requester's intent, which is completely valid, but other times there may be unintended consequences to these types of requests. So it's something you need to make the requester aware of. They may not know how many local initiatives are placed on the ballot, or how many regulations out there are actually more stringent than state statutes. So it's important to really give them an idea of what the consequences of such large-scale preemption are going to practically be. 5, after you've talked about the scope of the preemption and kind of know what you're working with, you're going to then start looking for any guidelines for drafting express preemption language, or look for models from state statutes or previous drafts. The Arizona Legislative Bill Drafting Manual contains very explicit instructions for drafting preemption provisions. And so in this particular state, there's requirements about what should be put in the heading. They give a great example of language to use. Other states, you might not have so much guidance. In Texas, our drafting manual doesn't talk about this, but we do have a lot of examples in our statutes. I've given a couple of examples here of positive language. Sometimes your requester might want to see that this chapter preempts certain regulations, exercises of authority. Other times they might want to see more negative language. They want it to be clear on the face of the statute that a political subdivision or local government is prohibited from doing something because it's included in the state's realm of regulation. Finally, after you sort of piece together how you're going to put together the express preemption language, you're going to want to talk to the requester about their intent with regard to the preservation of any local authority over a matter, and then include the appropriate language in the draft. And this can take several different forms. A requester, you might want to figure out if they want to prohibit any local regulation of the matter. That can be one preference. Sometimes the requester may want to allow local regulation of the matter that's more stringent than what's required statewide. In other circumstances, a requester might want to expressly accept certain powers of local government from being preempted, or clarify that certain authority of local governments is unaffected by preemption. Or there might be circumstances where the requester wants to preserve local ordinances or rules in a matter that already exist before the state enters the realm. And these are all circumstances that we encountered last legislative session in Texas. And so I'm going to briefly go through a couple of bills that were introduced and some that passed, and discuss how some of these types of methods of preserving or not preserving authority for local governments played out here in Texas in 2015. The first scenario is where a requester wants to prohibit any local regulation of the matter, and that was the case with a bill that was introduced during the last Texas legislative session, which would have given the state exclusive control over transportation network companies, companies like Uber and Lyft. And you can see an example of the language that we included in this particular draft, and basically removed municipalities or local entities' authority from doing anything with relation to these transportation network companies. In another situation, the Texas legislature heard a bill which would have prohibited smoking in certain workplaces and public places, and prohibited local regulation related to smoking. But this particular bill didn't prohibit more stringent regulation with regard to smoking by localities. Localities could further prohibit smoking. That would have been okay, but there was just going to be sort of a statewide floor put in place. And again, this didn't pass, but you can see an example of language that could be used in this situation. And this is some language that comes from the introduced bill, where you can see more stringent regulations by the state, by local authorities is allowed. Another bill that actually did pass in Texas last session was HB 40, and that bill is a great example of where the state was trying to take over regulation of a particular area, but they did want to carve out some authority for localities. And in this particular situation, the state was taking over the regulation of oil and gas operations, but they did want to carve out some authority for localities to still be able to regulate above ground activity, which is incidental to oil and gas drilling. So there's very specific language in this particular bill about localities still being able to regulate activity above the surface at drilling sites, regulate things like emergency response, traffic lights, noise. None of those abilities of localities would be restricted by the state's general authority to regulate oil and gas operations. Another example of this type of carving out or preserving authority for local governments was SB 267, which also passed last Texas legislative session. That bill prohibits local laws that prohibit a person from refusing to lease or rent housing to a person whose sources of income include federal housing assistance funding. However, that bill, it passed that prohibition against prohibitions, but it did include language that specifically provided that local governments that wanted to still have incentive programs for people to rent to people who receive federal housing assistance programs could do so. You could still incentivize that. You just couldn't prohibit people from refusing to rent to persons with that particular income. That bill also included a great example of what we like to call grandfather language. Sometimes a requester may want to preserve regulations that already exist before the state decides to enter an area. And that was the case with this particular bill. At the time the legislature was considering it, Austin actually did have on the books a prohibition against refusing to rent to people who had income from federal housing assistance programs. Someone during the process of the bill working its way through the system introduced language that would have grandfathered in Austin's ordinance. The state senator from Austin actually introduced an amendment that would have said that that particular provision didn't affect an ordinance or regulation adopted before January 1st, 2015, although ultimately that amendment was removed from the final version of the bill. So those are some examples of ways to preserve local authority and still expressly preempt state action or local action in general, but to, again, make exceptions for certain types of local authority. Now that I've sort of gone through a situation where a requester wants to expressly preempt local action in a certain area, I just want to touch briefly, I know we're getting close to the end of the hour, on situations where the request regulates a matter so extensively that preemption of local law in the matter may be implied, situations of applied preemption. You're going to handle these very similarly to the express preemption situations. Again, you're going to want to handle the request with political sensitivity. Here, you're going to need to inform the requester about the preemption. This is kind of similar to the federal context. Your requester may be very sophisticated in their knowledge of preemption, and they may be aware of it. They may be shocked that what they're going to do is also going to overturn locality in their district's ordinances. As appropriate, like in situation A, provide the requester with representative local ordinances or rules that may be affected by the legislation. This kind of gives them a real-world practical understanding of what local laws might be affected by what they're trying to do. And then generally determine the requester's opinion of the potential preemption and prepare the draft accordingly. If the requester is really concerned about the preemptive effect, if their district, if cities in their district have laws that they don't want to be affected by what they're trying to do statewide, you might consider including does not preempt language and make clear that what they're trying to do statewide doesn't touch certain things that localities might be involved in. Or in a converse situation, the requester might be really excited that what they're going to do is going to take care of what some localities might be doing. And so in that case, they might want to end up including express preemption language in the draft. And in that case, then you would go back to situation A and talk through, what's the scope of the preemption going to be? How are we going to phrase the preemption language? And then is there any preservation of local authority that we're going to want to be concerned about? So I think that is the close of my presentation. I really appreciate your attention, and hopefully this will give you a better idea of how to approach drafts that might involve state and federal preemption in your states back home. So thanks so much.
Thank you, Erin. So what I'd like to do now is open the floor for questions. Anyone who has any questions, please type them in the chat box in the lower left corner of the screen. I'm going to start with the first question, and that is, obviously this webinar has demonstrated that there's a lot of interest in hearing about issues related to federal preemption. And so this requester asks, what do you think is the most important thing for listeners to take away from this presentation?
I think the most important thing to take away is just to be aware of federal preemption and be aware of state preemption. I think a lot of times in our individual states, you can get very involved with what's on the books in your state, how your state does things, and kind of forget that states are, of course, part of a bigger puzzle and part of, you know, the federal government. And so I think it's just important to always have preemption on your radar and always be aware of that when anytime you get a request, just think about how what your requester is doing interacts with federal law.
Thank you. Okay. Our next question is, so originally the talk was going to be specifically tied to federal preemption. Why did you think it was important to add a discussion of local preemption?
I think state preemption, it rounded out the presentation. I think it's important to really consider both hand in hand. I think they're sort of the doctrines. They're very similar. They're sort of parallel in that, you know, federal law, of course, preempts state law, and state law preempts local law. So I think it makes a lot of sense to just to discuss them hand in hand and to understand all aspects of state and local preemption. They all kind of go together.
Thank you. So are there any other questions? Not seeing any more in the chat box. So with that, Erin Smith, I'd really like to thank you very much for putting together this presentation, and I really appreciate the fact that you included examples from multiple states. I think that was a really excellent way to convey some of the information. It was very useful for me since I work with so many states to be able to see that from multiple perspectives. So I really appreciate that.
Well,
thank you so much.
Thanks, I appreciate it. Bye.